Hello everyone, this is Rajiv S. Khanna for immigration.com, the law offices of Rajiv S. Khanna PC. I'm going to have a conference call with employers mostly. Coming Friday, April 26th, we'll go over the details of H-1B and L-1 reform, specifically these two visas, because there are some things to be aware of under these visas specifically. In my view, the restriction against outplacement is quite alarming. Basically, the restriction tells you that if you are an H-1B dependent employer, which means roughly speaking about 15%, 15% of your workforce is H-1B or L people, you cannot then do outplacements. The employees cannot be leased, they cannot be otherwise contracted for their services. So it's quite a serious matter. I'll go over the details this Friday. What I want you folks to do is, with a way of keeping in touch with us, the best way is just go to immigration.com. The slide that I'm showing you with this big red arrow, that link, Comprehensive Immigration Reform 2013. Click on that link. We'll be working on that page the most. I personally always go to that page and update that. Of course, stay tuned with me on Twitter. Download our app. Instructions to download are all over the place on our website. The apps are free. Right now we have the Apple, iPad as well, iPhone apps, and the Kindle is coming out in a week or 10 days. Did I say Kindle? I'm sorry. I meant Android. So that said, let's go back. What I want to do is just give you a flavor of the so-called reform. Much of this information is related to employers, but employees might find some use for it as well. I will be doing a series of updates. I will update you on family-based immigration, what is happening in the physicians area, what is happening in the area of individuals, how you can, if you are PhDs or master's degree holders, what kind of advantages you can expect. Investors, what kind of advantages you can expect, how they have dropped down the amount to 250,000 and 3 new jobs. So there's all kinds of things I want to talk about, but let me focus this discussion very quickly on H-1B L-1. This is an overview, very brief 10-minute overview of what I have seen. I'll be updating you on Friday, and before Friday I will try to get one of these discussions up and running so that you can view the video and the slides, and we can basically restrict the Friday to just discussion rather than information. So when you log in, just talk about your specific questions. That way, that's why I'm saying stay tuned on the page that I just pointed out to you. That said, let's go over the bottom lines. For example, on the H-1 side, as I said, there are severe restrictions on outplacement. You cannot outplace an employee if you are an H-1B dependent employer, and the requirements are as low as 15% of your workforce being H-1B people. You are also going to pay a lot more in filing fees, everybody, not just H-1B dependent. 5,000 to 10,000 per employee more over and above the fees that you have now. You will also have to advertise for 30 days before you even file the LCA. You will advertise for 30 days in an online website that the US Department of Labor will provide. And you will, of course, make the job available to US workers at that higher salary. What is that higher salary? First of all, there is no level 1 wage anymore. You'll have to pay at least level 2 salary if you're an H-1B dependent employer. Okay. The salaries will also be calculated by the Department of Labor differently, so that the salaries in general go higher for the H-1B employees. The Department of Labor, as well as the Department of Homeland Security, will have a lot more authority than they did before. DOL can walk in without notice if they feel that the circumstances require it. I'll give you the details of what are those circumstances. Um, the period for investigations can go back 24 months instead of just 12 months. So the limitation period has changed to 2 years. Um, Now there are penalties that only provide the minimum, there is no ceiling. So if they find that you've done something, even if it's a technical violation, you will be barred for minimum 1 year from participating in the H-1 or the L-1 program, and minimum 2 years for willful violations. What is the upper limit? Nobody knows. There is no limit set by the statute. There is also going to be an overall limit on the number of H-1B, L-1B people together, counted together, you can hire. No company in the first year, that is the target year, no company can have more than 75%, then it drops to 65% the following year, then the following year to even a lower figure, I think it's something like 50%. So the numbers keep dropping. You cannot, no matter who you are, you have to have your workforce. There are a couple of small exceptions. For instance, they've carved out a set of exceptions for organizations whose primary purpose is healthcare. There they have some exemptions. So, I'll talk about all of that, but I want you to be generally familiar with this idea. I am just surprised that there's not been a larger debate on the idea of outplacements, because 15% for any consulting company is not a large number. 15% H-1B employees is not a large number. In today's environment, that's common even for the largest organizations. So it's kind of interesting that nobody has made a big issue of it. It appears to me that is pretty much a death knell of a way of doing business which was common for a lot of small businesses. Rightly or wrongly, that has been eliminated. There seems to be almost the attitude of throwing the baby with the bathwater. We are, instead of curing the problem, we're just eliminating a source of livelihood for a lot of people. But I'm not sure I'm qualified to comment on the economics of it. I can certainly look at the fairness of it. It doesn't sound right, but I'm sure there's another side to this which we'll hear eventually, hopefully. The last point I want to make on the H-1 side is that there is now a private cause of action for employees. So if the Department of Labor finds out, and as a part of the audit, they find out that you've committed any violations, and those violations have hurt the employees in some way, like in their wages or in their benefits. In addition to what Department of Labor does, it looks like what Congress is saying is that there's a private cause of action, so you could end up being in court. And again, not a good way for a business to be run if we are constantly exposed to the fear of lawsuits. It would have been a much more tidy bundle if, as a part of the audit, the Department of Labor could also, as they do now, basically award whatever back wages, etc., are necessary. But again, I'm not quite sure what the eventual ramifications of this are going to be. Remember, this is merely a bill. It's not yet law. By the time it becomes law, I hope to see a lot more amendments in it. And then on top of that, we'll have regulations. So by the time the whole policy shapes up, we don't know what it's going to look like. But what it is right now is quite alarming from some perspectives. There is another, oh yes, I know that I was missing this point. This part is also very interesting, that Department of Labor, Department of Homeland Security have to conduct mandatory annual audits for 100 plus employee companies who are H-1B dependents. So on the L-1 side as well as on the H-1B side, there will be annual audits of these companies, and the reports will be published, at least the summary of the reports will be published publicly. Again, I think it's a major intrusion, but that's the sense of Congress. That's what needs to happen. So there you have it. On the L-1 side, it's very similar, a lot more fees, severe restrictions on outplacements. You cannot outplace to anybody except within your own group. A lot more investigatory authority. 100 employee companies are getting audited when they have a large number of H-1, L-1Bs. Investigation can occur without notice. Limitation period is 2 years now. Minimum bars of 1 or 2 years depending upon the kind of violation. Overall restriction on the number of H-1B, L-1B you can hire, 75, 65, 50, whatever that number is. Private cause of action, employees can sue you directly. So these are the two items I wanted to cover very quickly, so you can start thinking along these lines. And when I put out the next presentation, it might be a lot longer, maybe an hour and a half long presentation. It'll give you all the details. And if I'm not able to do it on Friday, I will present to you as much as I can, and we can have a follow-up call on Saturday, or we'll keep going until at least we've got the whole slew of issues nailed down and make sure that everybody understands what's going on. It's still early enough for you folks to make your voices heard in Congress. Then I wanted to cover these 3-4 other items that are interesting. That there is a intending, it's not intended, it's actually intending immigrant. That word is used. What that phrase is used. Whenever you count H-1B, L-1B numbers, they are saying don't count intending immigrant. That's an interesting concept. So what Congress wants to do is it wants to encourage employers to file for green cards as quickly as possible. In the count of your H-1B, L-1B dependency, they will not count the intending immigrant. And who's an intending immigrant? Important concept to understand. Easiest way to remember it is, if an employee's I-140 is already pending, they are not counted. I-140 pending, not counted. Labor cert approved or pending for 1 year. Approved, pending for 1 year. If the employer has a history in the last 12 months of filing 90% I-140s on approved labor certs, you'll be okay. So labor cert pending for 1 year or approved, and the employer has a history of filing 90% of their I-140s once their labor certs are approved in the 12-month period prior to filing for that particular individual, then you will not be counted. That worker will not be counted. Okay, it's a little concept. It's a little complicated concept, but suffice it to say, it's an impetus to file green cards as quickly as possible. H-4 holders will be given work authorization, but wait, nothing to get excited about. Only if the country from which they hail, if you're coming from India, for example, then India must be giving reciprocity to people in the H-4 holder situation in India. So if we have a similar visa for the H-4 holder and we provide the same kind of work authorization, only then the H-4 holder will get work authorization. So what they are giving with one hand, they are taking away with the other. I think this provision will be very difficult to implement, to study the laws of all countries. I'm not sure how long that would take. The third important point I wanted to make was that universities and schools that are for profit are not treated on the same footing as universities and schools that are not for profit. So university and school council need to be aware of that there is a distinction now between them who are for profit and them who are not for profit schools. I'll talk with you guys again on Friday. Most of this conference for Friday is geared towards employers, so I encourage employers only to attend. I hope that we have enough room in the conference. Otherwise, we'll have a recording anyway, and we can keep repeating this. On the Facebook page, my Facebook page for the firm, there were a couple of questions. Let me see if I can remember them. One question was, what will happen to pending visas, such as a relative's visa? And I don't think we need to worry about pending visas because I think they'll be processed to completion, and Congress will probably not disturb any of the existing rights conferred by those visas, or at least well on the way to be conferred. For example, even when you look at them eliminating the category of siblings applying for each other. So if your brother is a U.S. citizen or sister is a U.S. citizen, they want to apply for you. They're eliminating that category under this law, but they are saying you still have 18 months grace period to file a petition if you want for your brother or sister. Okay, so it looks like they are going to provide for that. So I wouldn't worry too much about that part of it. There was another question on Facebook this morning, and I'm sorry, it's completely slipped my mind. But we have by the way, we also have a community conference call on Thursday, a free community conference call for which you can post questions in the forums. So feel free to post your questions in the forums. I'll take them on Thursday. Then on Friday, we'll do the call with the employers. And once again, I want to remind you, if you go to immigration.com and click on this big arrow where this arrow is pointing, Comprehensive Immigration Reform 2013, I know it's a little inelegant, but I just wanted to get something up and running quickly. Click on this, and that page will give you an overview of the information that we have for you and the new developments in the law. I thank you for your time. I'll speak with you on Thursday as well as Friday then.